Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you're going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Erin.
Good morning, David. How's your week going so far?
Fantastic.
Awesome. Okay.
I can see into the future. It's going to be great.
That's good. So in this week's series, we're talking about bonds. So today in our 4 or 5 part series, what amount of bond is required?
That's a really good question, because a lot of times people go into conservatorships and they have a vague idea as to what the responsibilities are, and they get started and they go through all the paperwork, and all of a sudden they're at the court hearing and they're appointed and they say, yes, I'm appointed. And before the order signed, they have to post a bond, and they do the application, they go through it, and they're not qualified because they had no idea of this obligation. That's why you need to hire an attorney. But there's a calculation for bonds, and that is, first of all, generally speaking, you exclude the value of the residence from the bond requirement, because it's presumed that that is something that's going to be sold through court confirmation. You have to get court permission to sell the conservatee's residence in almost all situations, and they'll deal with the bonds issue at that time as it relates to the sale proceeds. So what the court looks at is, well, there's the universe of personal property belonging to the conservatee. Those may be stocks, maybe cash, and those are things that can be electronically transferred or turned to cash and put into a suitcase, and you can go away with it. So the value of the personal property needs to be bonded. Also, let's just say the conservatee is receiving a hefty pension or benefits from the Department of Veterans Affairs or Administration, or Social Security income. Well, it would be short-sighted to just set the bond for whatever cash is in the account on that day and completely ignore the substantial assets in the form of income to come in for the next year. So the court gets the value of the personal property plus the anticipated annual income for the year. And they also have something called a recovery bond, which is you get the sum of the personal property and the income, and then you add 10% on top of that. So that will be the amount of bonds. So if you have personal knowledge of your parents' assets, you see their bank statements, they have $100,000 in cash, and you know, let's just say mathematically we're very lucky and they exactly receive $10,000 in income. The cash plus annual income is $110,000. You add another 10%, which is $11,000, and that's your amount of bond. You need to secure a bond for $121,000. So that's how it's calculated.
Okay, well, thank you very much. And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.